Hello, everyone, and welcome to today's Experienced Practitioner webinar on the examination of non-traditional trademarks. I'm Jason Lott, the Managing Attorney for Trademarks Customer Outreach, and we are thrilled to bring you this webinar today. We have assembled a fantastic panel of experts to talk you through the whole topic of examination of non-traditional marks. We're talking about sound marks and motion marks and color marks and scent marks and all those fun sort of trademarks which don't get a whole lot of play. You know, they're the more rare sort of outer edges of trademarks, but they're very important, and we know that you want to hear about this, so we are very psyched to bring you this presentation today. So as you can see, we do have three great experts. I'm going to introduce them in just one moment, but before I do, just a couple of really quick housekeeping tips before we get going. For those of you who are curious, yes, today's session is being recorded. We're going to post the recording to our website and also to YouTube in about 3 weeks. And what about the slides? Well, yes, of course the slides are available. A link to the slides is in the email that you would have received before today's presentation. You can go back, open up that email, grab the link to the slides from there. They're also going to be available today. I'm going to make sure that Darcy and Amando, our WebEx techs, have a copy of that link, and they can pop that into the chat, so you can download them right now. And if you don't want to mess with the slides right now, you'd rather just sit back and take your own notes as our experts are giving you information. That's okay too. Don't worry. In the email that you get a couple days after the end of today's presentation, there will be a link to the slides, also a link to the survey, and for any of you interested in CLE credit, yeah, there is also a self-certification of attendance form. That'll all be part of the email that you get a couple of days after the presentation ends. So the chat is available to you, and so if you are unfamiliar with WebEx, that is down in the bottom right-hand corner of your screen. You'll see a little chat bubble. Darcy and Amando, they're our WebEx techs for today. They're going to be in the chat today and potentially posting some links in there for you. And it's also where you will find a link to live captions. We have Linda with us today who's providing the captions. Thank you very much, Linda. So if you are someone who wants or needs captions and you want human-generated captions, just open up the chat and you'll see the link for that. If you have technical problems today with WebEx, maybe you've never used WebEx before and you're like, I can't hear anything. Hey, we get it. Look, sometimes WebEx is new for everyone. So feel free to use the chat to communicate with Darcy and Amando and let them know whatever technical problems that you're having with WebEx. They will do their best to get them sorted for you. If you have any substantive questions about today's presentation, and I'm hoping that you will, I'm hoping that we answer them all in the presentation. Although I know that's not going to happen. I know you're going to have questions. So for that, we would encourage you to use the Q&A box, not the chat. For those of you who aren't sure where the Q&A box is, yeah, I get it. Look in the bottom right-hand corner of your screen. You're going to see 3 little dots. If you hover over those dots, or maybe you need to click them, you're going to see a little thing that comes up for your panel options. So open up those panel options. One of those options is going to be the Q&A. And that is where you can ask your substantive questions. Today, just open that, fire away. Please understand, though, we're not going to be providing written answers to the questions in the Q&A. Actually, what's going to be happening is we have a couple folks, in addition to me, I'm going to be taking a look at those throughout the day today, and I'm going to grab what questions I can, and if we're going to do our best to answer as many as we can before we run out of time for today's webinar. Please remember, however, of course, we cannot provide legal advice. We cannot provide pre-application analysis of trademarks and be like, hey, is this mark okay? Can I register this? Unfortunately, that's not a question that we can answer. But we do want to have your participation. We want to see what questions you have based on the information you've been given. So please feel free to put those questions into the Q&A. Again, bottom right-hand corner, 3 little dots, hover over that, you'll see the Q&A box option pop up. Okay, so let's jump in and to today's presentation. And to do that, I would like to introduce our panel of experts. So as you can see, today we're going to talk about the examination of non-traditional marks like those sound marks and motion marks, scent and color and repeated patterns, all that good kind of stuff. And to help us do that, we have our three experts. We have Corey Boone. He is the managing attorney for a new class of incoming examining attorneys in the Trademark Academy. And as a side responsibility, he is the lead administrator of the design code system for searching trademarks. Excuse me. Sorry about that. And he also edits the office's manual. Sorry. I get so excited about trademarks. All right. He also edits the office's manual for design code searching, and he started at the trademark office in 2006. We also have Carrie Genovese. She's the director for trademark petitions in the office of the Deputy Commissioner for Trademark Examination Policy. And in this role, she oversees the petitions office in deciding petitions and letters of protest. And she also advises USPTO leadership on petition and letters of protest policy and procedure. She began her career at the USPTO in 2005 as a trademark examining attorney. We also have with us, rounding out the panel, Jennifer Williston. She is the managing attorney for Trademark Law Office 105, where she provides expert level advice and management to a team of high performing trademark examining attorneys. She began her career as a trademark examining attorney herself at the USPTO in 2005. She worked for 4.5 years in private practice and returned to the USPTO in 2011. Okay, well, that is enough out of me. I am going to turn it over to our experts, but before I do, just want to give you a real quick overview of what today is going to look like. As you can see, we're going to start off with this overview of non-traditional marks and talk about the things that go into the analysis of whether or not a non-traditional mark is going to be registrable. Then we're going to get into those specific non-traditional marks themselves and really dive deep into what it is that we're looking for: drawings, specimens, descriptions, and so forth. We're going to round it all out with some filing and searching tips. I'm going to do some demos of Trademark Center and also our trademark search system so you can see how it works in real life. I'm going to give you a couple of resources and then we'll dive into those questions. So, Carrie, I am going to turn it over to you, and you are free to begin.
Okay. Can everyone hear me all right? Let me make sure about that.
Yeah, we can hear you, Carrie. Please
Excellent.
Go ahead.
Thank you so much, Jason, and good afternoon, everyone. I'm thrilled to be here today to give you some background on non-traditional marks. Just to clarify a bit about the terminology, we're talking today really just about trademarks, be it they're not the typical word or logo version. But for purposes of this discussion today, we will call them non-traditional marks, or NTMs for short. So when reviewing these types of marks, there are three main questions the USPTO examining attorney is going to ask. First, is the mark functional? Second, is the mark generic? As you may know, functional and generic marks are not registrable, even on the supplemental register. The third question is the mark distinctive? Most non-traditional marks are not inherently distinctive, but they can be registrable on the principal register if the applicant can demonstrate they have either acquired distinctiveness under Section 2F of the Trademark Act, or if they are registrable on the supplemental register. Turning now to functionality. Let's see, is that turning? Is it turning?
It's not. So there you go.
There we go. Okay, sorry. Trademark Act Section 2E5 prohibits registration of functional matter on the principal register. And the policy rationale behind that is that protection for utilitarian features should really be sought through a patent, a utility patent, which has a limited duration rather than a trademark, which can be renewed indefinitely. So functional product features and technology advances need to end up eventually in the public domain so that everyone can use them. Oops. Pardon me. The test for functionality is whether the mark is essential to the use or purpose of the goods, or whether it affects the cost or the quality of the goods. So if a particular color or shape of a product would make it cheaper to manufacture the goods, that may be an indication it's a functional feature and not registrable. These are some examples of functional features. The color yellow for safety signs. Yellow is bright and attention grabbing and commonly used to warn people of danger. The second example is the 3M case where the color purple was found to be functional for sandpaper goods. The board found that this color is a byproduct of the manufacturing process and so is functional, and all makers of that product must be able to use that color. Finally, with respect to trade dress for the interior of a restaurant, for example, the commonly shaped tables or windows are functional items and can't be claimed as a feature of the mark. So those functional features of the trade dress would need to be dotted out in the drawing or shown in broken lines, and we'll discuss that in much more detail later. And now we will talk about genericness. As with all trademarks, a generic mark cannot be registered, even on the supplemental register. So what does that mean in the context of non-traditional marks? If a particular color, for example, is understood by the public as a category or a type of trade dress, it might be generic because it's incapable of serving as a source identifier. The purchasing public will not recognize it as pointing to the applicant, but rather pointing to a particular category of goods. The generic test for non-traditional marks is the same as it is for traditional trademarks. First, what is the genus of the goods and services? And second, will the color, shape, etc. be understood by the public as a category or a type of trade dress for that genus of goods and services? We've got kind of a hot off the presses example in the PT Medisafe case, which was issued, the decision was issued in April of this year. The Federal Circuit determined that the color dark green was not registrable as a trademark for medical gloves because it is generic. The court affirmed what the TTAB had held, that based on the evidence in the record, this color of green is so common in the chloroprene medical examination glove industry that it cannot identify a single source and is therefore generic. So if a color has become so ubiquitous in the marketplace for a particular category of goods, it is not going to be registrable as a trademark. In the PT Medisafe case, the Federal Circuit applied the genericness test that they laid out in the Milwaukee electric tool case at the TTAB, as also shown on this slide, where they similarly found the color red generic for saw blades, based on all of the evidence showing that many different saw blade manufacturers chose the color red for their products. And now we'll move on to distinctiveness. As we talked about when looking at genericness, in order to be registrable on the principal register, the mark must be able to identify and distinguish the applicant's goods or services from the goods and services or others. Some marks are inherently distinctive, in which case they could be registrable on the principal register straight up, as we say here at the PTO. But if the mark is not inherently distinctive, the burden is then going to be on the applicant to prove the mark has acquired distinctiveness under Section 2F of the Trademark Act. This list gives you a breakdown of which types of marks may be inherently distinctive and which types are not, along with some important case citations at the bottom of the slide. So the Walmart v. Samara Brothers case found that product design is never inherently distinctive, while product packaging can be inherently distinctive. This product design versus product packaging analysis is definitely something examining attorneys will be looking at when you apply for your mark. Also, a single color has been found to never be inherently distinctive, whereas a mark incorporating multiple colors in a particular arrangement on the product might be inherently distinctive, as the Federal Circuit found in the Henry Forney case. So it's all going to depend, again, on the evidence that is provided. Commonplace sounds are not inherently distinctive, but it is possible for an arbitrary or unique sound to be inherently distinctive, and you'll see some examples of these later on. Finally, scent, smell, taste, flavor, and holograms are never inherently distinctive, and the applicant must provide evidence showing that they have acquired secondary meaning in order to prove that they are registrable as a trademark. While motion and tactile and texture marks can be inherently distinctive. So we'll see examples again of all of these different categories when the panelists expand on each specific type of non-traditional mark. And of course, every evaluation is going to be very fact specific and based on the evidence and analysis of the evidence that you provide. Turning to acquired distinctiveness evidence. As I noted before, the burden is on the applicant to submit evidence of how they use their mark in commerce in order to demonstrate that the public will recognize that use as identifying the applicant as the source of the goods or services. So I wanted to offer a couple of tips from our experts about proving acquired distinctiveness. The first tip is to front load your evidence in the application itself. This helps reduce the back and forth time and can move your application to approval quicker. Another tip for when you're filing your application is to avoid overly broad identifications of goods and services. If you identify 15 lengthy classes of goods and services, it could make it harder for you to prove acquired distinctiveness because you'll have to show that you have that bona fide intent to use the mark on each and every item you identify. Finally, one of the best types of evidence you can submit is look for advertising. This is the classic example from UPS, what can Brown do for you? This type of evidence is excellent to show that the applicant is actively promoting the color, sound, or other non-traditional mark as a source indicator and using it as a trademark separate from their other more traditional logo and word marks. So as it says on the last bullet point on the slide, recognition by the public is key to establishing acquired distinctiveness. And now we I'm going to speak just very briefly about general drawing and mark description requirements. And then the other panelists will do a deeper dive when they discuss the specific requirements for each type of mark. The first thing I wanted to clarify is that a drawing is not required for sound, scent, or other non-visual marks. For those, the mark drawing will usually be coded to say something like non-visual mark or sensory mark. But for marks that do have a visual component, the drawing can only show one mark, so you can't register multiple marks in a single application. The drawing must also be a substantially exact representation of the mark, and the drawing, this is the most important thing, the drawing must make it clear what features are being claimed as the mark. So this is done by adding broken or dotted lines to indicate the portions of the drawing that are not being claimed. And then in the mark description, you will be required to indicate that the dotted lines represent, for example, the goods to which the mark is applied and are not being claimed as a feature of the mark. And as I said on the last slide, a drawing can only show one mark. So what happens if your mark is used on a three-dimensional surface? Trademark Rule 2.52 states that a drawing for a mark shown in 3 dimensions can only include a single rendition of that mark. But in some cases, you can't view the entire mark in one rendition. So in this situation, you can file a petition to the director with my office to ask for a waiver of this single rendition drawing requirement. And then if the petition's granted, you will be permitted to show multiple views of the mark in the drawing. So for one of the examples on the slide, you cannot view the entire mark on this cold brew can without turning it in your hand, right, to view all the different angles of the mark. So in this case, we granted a petition to allow the drawing to include these 4 separate renditions of the mark. These petitions are routinely granted, but a granted petition is not a determination that the drawing is acceptable. The examining attorney is the final arbiter of whether the drawing is acceptable, and they will often require additional edits, like adding dotted lines around items that are functional or generic that you are not claiming as a mark. My biggest tip here is to file your petition as soon as you receive a serial number for your new application. You do not have to wait to receive an office action. In the petitions office, we do try to expedite these petitions to allow multiple renditions of the marks so that we don't hold up examination with the petition process. This is another opportunity to avoid an office action, refusing your drawing and requiring a petition. If you just petition right away, by the time the application is assigned to an examining attorney, you could already have a granted petition in the record ready to go. So thank you so much for your attention on my slides. I am now going to turn the presentation over to my colleague, Jennifer Wilston.
Thanks so much, Carrie. Let's make sure I have control of the slides.
Yes, you should.
Got it.
See, did it go?
Just hit the down arrow. You should be ready to go.
There we go. All right. So I'm going to talk about trade dress generally and then repeating patterns in the next few set of slides. This slide shows an example of some different trade dress, which also feature aspects of a repeating pattern. When we talk about trade dress, we're using that term generally and almost as a synonym for a non-traditional mark, because all of the non-traditional marks are different types of trade dress. Talking about product design, product packaging, and then that tertium quid, the trade dress for services. And you can see here on this slide, we have an example of product packaging, and then we have two different trade dress slides for trade dress marks for services. Have an absolute bottle that actually has two different type of repeating patterns within the label of that bottle. The mark is actually for the repeat on the label. Then we have a guitar-shaped building, and we have the sari that's used in charitable services originally, I think, for the Sisters of Mercy. So each of these were different marks that were applied. The registration numbers were there, and you can see with respect to each of them that there's some dotting in the mark drawing. So we'll talk more about that as we go through. And interestingly enough as well, the absolute bottle as well as the sari were filed as repeating patterns that then are examples of trade dress for product packaging and trade dress for services. These are specific repeating pattern examples. We have Marc Jacobs of signature repeated a number of different times that's used in its advertisement of its retail store. We have the fish garment that's used in entertainment performances, and then we have pink box that is a building design, all mostly dotted with a repeating pattern that comprises sprinkles. You can see again how we have different aspects of the repeating pattern. You may be asking, what specifically is a repeating pattern? Well, a repeating pattern consists of a single or a repeated element that is appearing on the mark or appearing on the packaging for the goods or with respect to the services. Turning to the drawings, which were highlighted there in the prior slides, the drawing must show the mark as applied to the specific goods or the product packaging or used in connection with the services. Broken or dotted lines are going to clarify the marks, the portions of the mark that are not claimed as portions of the mark. And it's really important that that is clear what is claimed as part of the mark and not claimed as part of the mark. You saw on the prior slide with Marc Jacobs, and we have some examples on future slides, a swatch drawing. Now, a swatch drawing is a repeating pattern type drawing that is not generally acceptable without substantial evidence. It's essentially there is additional evidence, additional evidentiary showing that's needed to show that there is a consistent use of the pattern across the different products or in connection with the services, and that the dotted out drawing cannot be of the placement of the pattern on one of the items in the identification of goods cannot be an instance where it's representing all of how the pattern is used, but it still is creating a same consistent commercial impression. With the swatch, what we're concerned about and why we often do not allow for a swatch drawing is that we don't want to have multiple marks registered. Now, specifically for trade dress, the mark description goes right along with the mark drawing. The mark description generally for all trade dress, and we'll have some more for some of the more specific non-traditional mark categories that have distinctions with this, but you need to clearly indicate how the mark is being used on the product packaging, or the services. If it's a three-dimensional mark, you need to make clear that the mark is three-dimensional. In the mark description, you should also indicate if it's a product design, a product packaging, or a trade dress for services. And then we talked a lot about the dotting. Dotting typically represents matter that's not capable. Either it's functional or generic. That elements need to be dotted, or if it's representing placement, to give an example of how the pattern or the trade dress itself, or you'll see in other instances, is intended to appear. You might have some dotting there with respect to the mark, but you're indicating specifically in the mark description that the dotting is not claimed as a portion of the mark. Now, specifically for a repeating pattern, you need to indicate that the mark is a repeating pattern. You need to describe again how the pattern will appear on the relevant items. You might have one item in the identification, or might have several. There needs to be a consistent appearance of that pattern across the different items. And then also you need to sufficiently describe the nature and repetition of the complete pattern. So when you think about a pattern, I know there's like a little bit of a pattern even on the background. If you're only registering, you're only showing it in the mark, you don't have the complete repeat of the pattern, we might need to see more of that to be able to see exactly what the commercial impression is with respect to the drawing. Similarly, if you're looking for a swatch drawing, which again has a very high bar to try to get that swatch registered, you're going to need to show the consistent look across the different marks and indicate what the usage consistently across the indicate what the usage of the pattern is across the items, whether it's all across the body of the products, or it's only a portion of the product. And that needs to go into the mark description so it's clear what the mark actually is representing. Now, looking for specimens, generally within any of the trade dress drawings, you need to have a specimen that shows the use of mark in the on the product, or if it's this trade dress for services, it's in the advertisement or the rendering of the services. So here we have three different examples. A milk can, that's for a ice cream shop. And then we have the toadstool in the center, which is a bar toadstool design that was actually part of restaurant decor that was pulled out as a registered mark. And then sort of a wine barrel or wine cake, I guess you would say, as part of the tours and wine tours located in Chicago. So in here, each of these, the specimens are representation of the mark as appears in the drawing. And you can see in instances where in the mark drawing there's dotting, that there is that those elements are still there, as well as there may be actual lettering that appears in the specimen that is not claimed, because that's not claimed as part of the drawing. Here we have 4 different swatch examples for repeating patterns. Excuse me. These all had substantial showings, and you can see how the pattern then is represented in the swatch. The specimen example is there, but you have different examples with respect to the Louis Vuitton bag. You have the cabbage cheese, you have Victoria's Secrets, and you have the porcelain fishtail design there across all of those different drawings. Again, it has to have a substantially exact representation with respect to the specimens and matching there. Turning next to color marks. Here are some examples of color marks. These should hopefully be very familiar to you because, again, we've had a substantial showing of evidence that the color is distinctive with respect to each of the examples here. You have the Tiffany boxes, you have Godiva boxes, John Deere, the green and yellow on tractors, brown, which Carrie had referenced previously, and you have a red sole shoe. So with respect to a color mark drawing, the drawing must show that the color is applied to the goods or used in connection with the services. We actually don't accept swatch drawings. With respect to color marks, you do have to show how the color appears. You can have a single color or you can have an arrangement of colors that you can see there in the John Deere tractor example where you have yellow on the wheels and you have green on the body of the tractor. Again, the dotting is indicated to show placement. For a color mark description, you need to include the colors claimed, explain how the color is being used. That's similar to how it is in a repeating pattern, but how it specifically is used, and that indicates that the shape of the item is not claimed as a feature of the mark, and it's only used to show placement. And by indicating this, while you're having one item as representing how the color appears, the mark description is really key in explaining how it is going to be appearing on the entirety of the goods that are listed in connection with the color. So here, for an example, the goods are oil filters, fuel filters, filters for motors and engines, hydraulic filters, lubricant filters. And the mark description is the mark consists of the color blue as applied to the entirety of the filter. The shape of the filter is not a feature of the mark. It is only used in dotted lines. And so, here you might look at this and think, okay, well, this is only going to be used on a blue cylindrical filter. It's not necessarily the case. The showing was made for blue on filters, and that's with respect. And this, with the dotting, is just a representative evidence, a representation of the color that was registered. So here, with respect to the specimen, you can see there for the filters, excuse me, this is the same specimen from the blue cylindrical filter on the prior slide. The shape of the goods is not claimed, and so you have potential different sizes there. On the specimen, you have a certain size, and you have other sizes and colors, smaller in the lower right-hand corner. But I wanted to be able to show that there's, different, the shape of the goods is not claimed, but the specimen can show different shapes and sizes. That's the point I was making on the prior slide with respect to the dotting there, that the color is what is claimed as the mark, and the dotting is just a representative usage. Here again for services, we have specimens that are advertising showing the mark, and that can be photos of the color appearing in the advertisements and showing the mark with respect to how the advertisement appears. So you have here brown on the UPS truck. The representation is there on the truck. And then I think it's the nerd. Just make sure I have that quoted properly. The nerds on site. I was about to call them the nerd squad, which and it does say that in the specimen there, but that is the color red applied to the entire surface of the vehicles. Turning it now over, sorry, went too far, to Corey to talk a little bit about sound and motion marks.
All right, Corey, I'm going to give you control.
Great. Thank you. Thank you, Jen. Thank you, Jason.
Okay, it's all yours.
All right, I have control. Hi, everyone. Thank you so much. Thank you, Jen. I get to talk about some fun marks, essentially what we might categorize as sensory marks. These are perhaps some of our rarest non-traditional marks in general in the office. First up, sound and motion. I've got a few examples. And these are, typically encountered in television, film, radio media, often as, commercials or things like that. Let's see if my click works. If I can advance the slide. Might be a little delay here. Hope that should work. All right, so let's play some examples. Be careful, this one might be a little bit loud coming through. So that's the famous yell uttered by Tarzan, I think owned by the estate or trust for Edgar Rice Burroughs. All right, next up. Oh. Sorry about that. All right, I'll try this again. Oh. Let me advance it right. I'll just click the play. Sorry, there's a little delay here. Okay, let's try this one more time. All right, the chime, famous by broadcast station NBC. And this one, there's no sound, but this is the jingle for Farmers Insurance. I'm sure you've seen these commercials with the actor from Whiplash. A very fun one. So like I said, these are fun. We've all encountered these plenty of times. They may stick in our head and appear when we least expect them. So they can vary in length, sound marks. They can be as long as full jingles. The farmer's one's a shorter one. Think of a longer one might be the Toys R Us. I don't want to grow up. I'm a Toys R Us kid. A series of notes, as we saw with the NBC chimes. Could be a series of syllables with McDonald's has a live registration for ba-da-ba-ba-bum. Or it could be just a single sound if we think of MGM Entertainment Studios and the Lion Roar. So those are some other examples, not on the slides. And similarly, with motion marks, again, media is where we most often encounter these. And so I'll play these examples. This would be HBO, the cable network. And this is the opening titles for Pixar animation. If you've seen Disney Pixar movies, I'm sure you've encountered this lamp. The previous one was, of course, the HBO one. A key thing to note there is motion marks will sometimes have sound with them. In that case, the TV static playing in there. And I'll come back to the drawings here in a second on the other slides. But one thing to note about these is they show up to 5 panels to depict the movement or change. It doesn't necessarily have to be straight up movement, as we saw with the HBO one. It could be a little bit more of a fading in and fading out, that sort of thing. So movement, motion, sort of considered loosely, just any sort of kinetic activity going on with either sound or motion marks. Slide advance. Keep looping here. Okay. All right. So drawings is sort of a misnomer for sound and motion marks because the TMEP, our Manual of Examining Procedure, do not actually require drawings. Now, in our systems, you may see placeholders consisting of blank titles that either say sensory mark or no drawing, non-visual, a gamut of things. You may even see what looks like our traditional drawings that might depict wording or the sounds. In the McDonald's instance, you'll see the words ba-da-ba-ba-ba written out in what looks like a drawing page, but it's not technically the drawing. In the case of what we saw with the farmers, you may see that as a drawing where the musical notation, lyrics, if applicable, will appear, but those are not considered drawings per these types of marks. And again, with the motion marks, they're by definition visual marks. There will be at least one frame image, but up to 5 without needing any sort of petition to have those multiple framed drawings uploaded into the record. Let's see. Mark descriptions for sounds and motion must be pretty specific. As we saw, there's often a lot of syllables, a lot of notes, what have you, and so the mark descriptions tend to be more detailed to capture this, to sort of help represent the claim of the owner of the mark for what is encompassed in the mark. I won't read this long mark for the Tarzan yell, but it was a few seconds of sound, and here we see hundreds of words to explain what notes are involved in there. And this one would be the Pixar equivalent that speaks about the animated lamp moving around the letters and stuff like that. And again, with the HBO one, if there's also sound, that will also have to be discussed as well. So I think in that case, it's something pretty simple like the sound of television static. Specimens, proof of use of these marks are video files or audio files as needed. And so our system, accepts a variety of media files that you can submit with the application or in responses as substitute specimens, to illustrate how they're actually used, how consumers encounter them, either at the start of a movie when it comes to the MGM Lion Roar, they're watching The Wizard of Oz and the lion roars, or they're listening to a television a radio jingle or something like that, and one of these come on. So our system, can take a variety of forms. Here is a screen capture from our trademark center that discusses JPEGs, waves, MP3s, and things like that. To come back to something, Carrie was discussing a little bit, distinctiveness considerations with sound and motion marks are essentially the same as any other mark. As memorable as these are, it all comes down to, the goods or services for which they're used. So for example, the sound of a chainsaw may not be inherently distinctive. It may not even be registrable if the goods are chainsaws. But the sound of a chainsaw for an alarm clock, well, that's a little bit different. That's a little bit unusual and unexpected. So that's something to consider. And so like a lot of these, it all depends on what the goods or services that the sensory mark is being used for, and how that relates to distinctiveness. Okay, moving on. This is our older system, filing system with T's, and again, shows how that those media files can be accessed. And again, I think Carrie mentioned that the slides will be available after the presentation. I know they come across a little bit small. And so whereas, I said the sound and motion are pretty rare marks, numbering in the 300s, give or take, for sound and 100, 200 for motion and sound. These last non-traditional sensory marks, scent, we should also mention taste, and tactile marks are the rarest of the rare. There's only at most 25 live active registrations or pending applications for these types of marks, but they're also kind of fun. And again, what I just said about the context of the actual goods and services is important here. If there's a scent of cranberries for a candle, well, it's common to have scented candles, so that might not be not only inherently distinctive, it might be generic. But a particular smell of fun clay for playing, again, this example with Play-Doh, that might be inherently well. I'll say scent marks, taste marks, tactile marks can never be inherently distinctive, but it may be registrable because it's sort of unusual. The scent of a bowling ball. I don't know if anyone's ever stopped to smell a bowling ball, but that's possible, I guess. The last one, the scent of your motor oil. There you go, strawberry scented motor oil. So, it's kind of that unusual use, unusual encountering in the marketplace, that is what makes these memorable in a consumer's minds. And that's what we care about, to register things that are, capable of pointing to a particular source. So these other examples, the shoes with the scent of bubble gum. And I can't quite tell what these, if this is a candle, that might be a little bit more problematic, perhaps, if it's oranges smell, but it is registered, so I don't know that example in particular.
I think it's shoe polish.
Oh, shoe polish. Well, that's much better than candles. Want our shoes smelling fresh. Okay. So these slides just indicate, some of the same things I was talking about. The actual smell of the product, or services as people encountered them. I think, there are examples on the registry of going into a particular type kind of store and they for each year. But again, if they're utilitarian, air freshener, candle, that sort of thing, that would be something we worry about. We don't have any examples of taste marks live in our system right now, but again, that would be, perhaps something that you would taste but not consume. So I'm struggling to think of an example. Hopefully not a bowling ball. And then again, these have no drawing requirements, but they may, have those sorts of placeholders too in the system to sort of, give a representation of what the scent or taste may be applied to, but they must be accurate and complete. But they're usually briefer. The mark consists of the scent of, strawberries applied to motor oil. Physical specimens will be mailed in these cases. So again, that's an interesting, our rare, what we call bulky spec situation. But we would have to smell them and make sure it's accurate. Again, tactile marks, not too common, but this is the case of a very, the physical sensory touch applied to particular goods. Again, there's not very many examples of these, but it would typically be something kind of unusual, not expected for the goods you're using. Imagine you were using a hammer and for some reason the handle was like a furry gorilla. Something like that. That would be very sort of strange, but potentially registrable. But again, none of these sensory marks are capable of being treated as inherently distinctive. As odd as that might be, it's just sort of analogous to sort of what Jen was talking about with product design, because these are definitely the products themselves, and product design cannot be inherently distinctive. Because these run up against patent law, to say briefly. And this slide just sort of talks about that again. All right, I think with that, I'll finish this last slide and kick it over to Jason. Okay.
Okay. All right. Well, thank you very much, Corey. So folks, what I'm going to do right now is take you through a couple of live demos. We're going to talk about filing a new application, what that would look like. So I have some screenshots that are here in the deck itself. I'm going to give you a live demo, but the deck is available to you as a resource. So later on down the line, you can open up the deck, go back and say, oh, what were those screenshots again? They'll be right here for you. For those of you who didn't hear at the very beginning of our presentation today, the slides are available. If you check the email, you got about an hour or so before this presentation began. You'll find a link to the slides in there. We can put them in the chat here today. You'll also be able to get a link to the slides in the email that comes a couple days after the presentation. When we move into the question and answer session, I will grab the link and throw it into the chat for you for those of you who want to download it today. So what I'm going to do right now is flip over to our website. Oh, good. Of course, it is logged out. So let me sign back in here into my USPTO account, and I'll be able to take you through. All right, let's see. Okay, here we go. All right, so I started this already just to be able to move more quickly through it so we can get to your questions. So let me jump back in here and edit this application that I've already started. So as you can see here, we're jumping right to the trademark details section with the mark selection. So most of the time, right, as Corey talked about, the odds are most of you are going to be filing either that standard character or special format drawing. But here we're going to do something different. Okay, we're going to apply to register something else. And as you can see here, three-dimensional product design, packaging, and so forth. So I already have the radio button clicked here. So I'll just go down to the bottom and I will hit continue. And then we go a little bit deeper. So I know, yes, this is potentially more clicks for you and things like that, but this really helps us on the back end be able to better categorize what specifically it is that you are applying to register. So as you can see here, you can choose amongst the options. I've already selected sound because for this example, we wanted to do a sound mark. But as you can see, all the options are here. So the radio button for this, I already have that selected. So I come down here, I hit continue, and then we get to this page, which is the mark drawing upload, which again, very weird for a sound mark because you don't really have a drawing, but still you'll be uploading stuff, and this will be the sample. So you can, as you can see, drag and drop just like you would typically do if you were applying to register a special form. I'm going to go ahead and hit browse file here. I will grab it out of one of my folders. Here we go. And I'll hit open. It'll upload it into the system. Okay. And so you can see here, I've got the little sound mark right here. You can play it to make sure, yep, that's the one that I wanted. And obviously, and if it's not, then you can upload a different file. So once that is up and in there, we can hit continue to move on. Here we go, trademark drawing. If it's set to music, you might want to submit that musical score. So you can hit the button here to add the sheet music. Again, it's a drag and drop. Just go ahead and pull it into the system, nice and easy. I'm not going to do it here just for example purposes. Then we hit continue, and then we get to the part that's a bit more complex perhaps, which is that sound description. So as you saw in Corey's example there for the Tarzan yell, hey, pretty in depth, all right? And so here I've just, kind of made something up here and already put it in here. But this is the sort of thing that we are looking for. So we can sort of know what those notes are. What is it exactly that the consumers are going to be hearing when they're hearing your sound mark? And you just type all of that in, and when you're done, hit continue, and then you move on to the next part of the form, which is all the stuff that you are typically used to, translation, name or likeness, and so forth, until you get to the things like filing basis, in which you would just go ahead as normal and upload your specimen, which again would be how you're actually using it out there with members of the public. So that's a real quick dive. I just want to do a real quick demo for what that would look like, because my guess is most of you are used to filing those standard character and special form format drawings. So it's a little bit different, but should be pretty straightforward for you. All right, and as I said, all of these screenshots are here in the deck, so you will have a visual for what you should be looking for when you go through and are going to file for one of these. Okay, now I want to transition here into searching for non-traditional marks. And so what I would always recommend is, certainly for all you experienced practitioners out there, those paralegals and administrators and the folks that are doing all of the day-to-day, all the professional support. What I personally would recommend is focusing your attention on Field Tag and Search Builder. Yes, I know that our public search system has all of these drop downs, general search and mark description and goods and services and owner and all that sort of stuff. Sure, yes, those can have those purposes. They can be useful in somewhat limited circumstances, but personally, my recommendation for you would be to use Field Tag and Search Builder. And like I did with the application here, I have some screenshots in here so you can see exactly what it is that I'm talking about. And I'm going to flip back and forth here between the slides and the actual search system so you can see this stuff happening in real time. So a couple of things to keep in mind with the Field Tag and Search Builder is this is going to be very similar to what you used to be doing in the old version of the system. I know we don't talk about tests anymore, but essentially you can do everything you did in tests and more in our new system. It's just a slightly different syntax that you have to learn, and once you have that figured out, trust me, you're going to be good to go. So one of the things that you can do with Field Tag and Search Builder is you can use all of these amazing field tags that we have, which are essentially ways to direct the system to look into very specific buckets in our database. And so one of the field tags that isn't talked about a whole lot, but you could use, is this mark drawing code. That is different than a design code. A mark drawing code is going to tell you what sort of not type of mark, but what the format is going to be, whether it was an old school typed drawing, whether it's standard character, whether it's stylized, whether it's a design, and so forth. And we have a list of those things available for you. I'm going to open up here. I already have it opened up. This is in the search. This is the help area. Let me just bump up the size a little bit here so you can read it better. Under the Advanced tab in the trademark search, if you scroll down here to the search fields, all you have to do is type in something like MD, that's the mark drawing code, And as you can see here, you can see all the currently 6 different codes that we have. So 2 and 3, for example, are for design or design plus wording. So if you only wanted to focus your search on designs or design plus wording, you could just use mark drawing codes 2 or 3. If you just want to look at standard character, okay, you could do that for 4. You might also want to do 1 for type drawings for those old drawings before there was standard characters. And 6 is also a really cool one where a lot of your non-traditional marks are going to be living, the ones for which there really is no drawing that's available. All right, so there are all these different codes that you can use. We're going to try a couple of them right here. I'm not signed in, but let me go ahead and sign in here real quick. We always recommend signing into your USPTO.gov account to make sure that you have access to all of the benefits of being inside, such as the ability to in terms of your export and things like that, get access to that one-page summary that I know a lot of you practitioners are interested in. And so all you have to do here is really type in something like MD2, MD3. So this is going to get stuff that has the mark drawing code 2 and the mark drawing code 3. And so we could run that if we wanted to. Let me turn off the beta here, but as you can see, this is going to get us a lot, 2.7. Ooh, that's a lot, right? Things that are tagged for stylized, or it's like a design or stylization and a design. But we could also narrow that down, right? And so if we only wanted to look for things that are product configuration, okay, we could say DE. DE is for the mark description, and we could say something like configuration with an asterisk, which would get us configurations. We could probably even shorten it to configure with the wildcard at the end to get all those sort of variations. And if we only want to look at live stuff, we can say and LD:true. So as you can see right here, this is going to find us stuff that's in mark drawing code 2 and 3 with the wording configure or configuration or configurine. Right here in the design, in the mark description, and it's only going to get us live stuff, none of the dead stuff. So we hit the little the magnifying glass here, and you can see it narrows it down all the way to 8,000. Hey, not bad. All right. So as you can see here, you could go through and take a peek at all of these, and these are going to be ones that have the word configuration in the mark description. Go ahead and open this up right here. As you can see right here, I guess for some reason it decided to go into the beta version of it. We can take a look at the details here. Obviously, that's what the mark looks like. In the mark information section here, you can see the description. So a 2-dimensional representation of the mark, which consists of the shape, design, and configuration of the goods. Right. So that's how you could dive in and look at those things. So this is one way to do it, is to just string together a couple of things, such as the mark drawing code, whatever term it is that you're looking for in the mark description. And of course, as you all know, LD:true is going to get you the live stuff instead of all of the dead stuff. So that's one thing that you can do. Let me hop back here into the PowerPoint. So this is one way to go about it if you're looking for product configuration or packaging. You could also use the word packaging if you wanted to. If you only wanted to pull up stuff that was packaging instead, you could just, something like this. Okay, and you can see here, we're pulling up stuff for apparently the packaging for an automatic dishwashing detergent, or for our various fragrances, colognes, and perfumes and whatnot. So here we go. Right, so you can see all of the different packaging sorts of things that happen to be in here. So this is a really handy tool, the DE description, to really dive you into what it is that you want to look for. Okay, so that would be for product configuration or packaging. Very similar thing here if you're talking about a repeating pattern, right? Jen showed us these really great examples of repeating pattern things. Obviously, you could do the same thing here. And all you'd have to do is, take this out right here, type in repeat. And again, the asterisk is that wildcard, so it's going to get repeated, repeating, repeats, and so forth. We do a little search on that, and you can see here we have under 2,000 anyway of applied for and registered marks that have the word repeating in the mark description. So here we go. This is what the beta version of TSDR could look like once it's integrated into the search. But you can go ahead and hit view details to go old school TSDR. And then you can dive down in here and check out the mark information. And you can again see the description of the mark, right? Which says repeating pattern of circles on a shiny outer surface, okay, for these particular stationary products. All right. So moving right along. So that's repeating pattern. Color, if you're only looking for something that is like a single color trademark, and one of the things that you can use is a design code. Different than a mark drawing code, it is a design code. These are the 6-digit codes, and as you can see, there is one design code that is specifically for colors or color only or a couple of color marks, things like that. And that's 29. So you might recall for the way that design codes work is it's kind of 3 sets of 2 numbers. So it makes up a 6-digit code, and they're all sort of divided out that way. So 29 is going to get you these like single or multiple colors trademarks, and then the second one is going to be whether it's, you know, sort of like, I forget whether it's appearing or how the color is used, and then the final one is going to be the color itself. You see an example down here, DC:290207. That is going to get you stuff that has orange all over the entire surface. And so one way to go about it is you're saying, well, I don't know if it's a single color, if it's a multiple color mark. We can really dive into our use of the parens and also our use of the wildcard in this circumstance. So as you can see, this would be a design code, and then it's going to say, okay, what all is in your design code? Could be 2902, and then the asterisk means it could be 290201, 290202, 290203, and so forth. And you can do that all the way through. And so I can go ahead and show you that real quick. It's going to take me a second to type all of those in, so please bear with me. And so as you can see, all we have to do here is 2902 asterisk. The space in this case is an or, so we don't have to type or every single time. If you want to save yourself some keystrokes, oops, I need to put the asterisk on there. 2906 asterisk, 2907 asterisk, and then of course we close it out with a paren. So much like you might remember from algebra or whatever, it's going to do everything that's inside here. So it's saying, hey, search system, give me anything that has a design code that begins 2902, 2903, 2904, and so forth. Let me hit the magnifying glass here. You'll see what this looks like. And then here we go. You can see, apparently, I guess this would be White Claw, right? I think is what that is. And so you can see these have the use of color here, right? Here. This one right here for Hairball Productions is going to be this color, I guess apparently used on these electric hair curling irons and so forth. Right, and so here we go. This would apparently is Prince and the Prince Estate here. I guess the color purple used on these buildings. Okay, for entertainment services and so forth. Now, one of the things that you might notice is design codes are usually put in at the very beginning during the pre-examination. Sometimes design codes change. Sometimes things are coded incorrectly, and they get fixed when they get sent to the examining attorney. So you may see some stuff in here that you might not necessarily expect, but it's okay. It'll end up getting getting corrected in the end. So just be aware, this is one of the reasons why doing a one and done search is never a great idea, is because you might just go, oh, cool, I just did this one search, I should be good. Well, maybe not. You might want to think about an alternate way of searching as well. And an alternate way of searching here could be, for example, instead of doing a DC, you would do a DE, and you could use the word color. And so you could do something like, here, I'll just show you real quick. Maybe it might be in here like this. It might not. You could think about doing something like, oops, color mark. It might be in the mark description where they've said, oh, it is a color mark, which is the color yellow, green, or whatever color that happens to be. So there might be different ways that you want to approach it, so you can make sure that you're seeing everything that you want to see, so you're making your good choices during your clearance search. All right, let me keep on going here. So for sound marks, for example, again, you could set it up using that same sort of system, MD colon whatever, a little description for the wording that you're looking for, followed by LD colon true. So here we're going to change it up a little bit, and we're going to go to MD6, which is for trademarks that don't have a specific drawing. And so you might do something like sound. Maybe that's going to get you too many, okay, 369, right? So you might, okay, here we go. This is going to be Tarzan right here for the Edgar Rice Burroughs Inc. And apparently it looks like perhaps Tarzan was also, the yell was used with slot machines. So, okay, good job. And so here, so this is going to be Lucasfilm, right? So the sound of the lightsaber is going to be here. Also, we'll probably find the Darth Vader breathing. I think it's for Halloween costumes and things like that. That's probably buried in here as well. But this is one way to go about it by using the word sound. This is probably going to get you less stuff, but you could try it if you wanted to see if anyone has this sort of in there as sound mark. Again, see, you're going to get less, and you always want to be careful you're not getting too few. So this is another way to approach it. You can fool around with these sorts of things, right? So we got a little Homer Simpson going on over here. And again, you can see the way this one's registered. You can see this looks like at this point we just simply uploaded the mark drawing page, and that's what the visual was. But as you can see, as Corey noted, you might see these different things, whether it's called sensory mark or no image or visual, non-visual mark or something like that. Or this one apparently for TiVo. So again, just different ways to fool around in here and just using whatever you think is the right terminology to help you find what you're looking for. Same thing is going to be true here for motion mark. Let me just do this one real quick. So here we're going to go back to looking in our various mark drawing codes. We could do 2, MD3, MD5. And we want to look for motion marks. So we can just adjust this right here. And there you go. Looks like 247 of those that are in here. And so you could go through and take a look at all the various motion marks that happen to be here. So that is one way to go about it. All right, let's see. Oh yeah, let me do this last one here. Again, these are really rare, but again, you get the picture, okay? What you're doing is essentially using the same sort of setup every single time, and you're just popping in different words for what it is that you're looking for in that mark description. So I'll just do just do this one as an option right here. Let's do, this will be a 6 because there is no mark drawing for scent marks, but we could do something like, and maybe I'll do scent, smell, what else did we do? Fragrance and olfactory. Okay. And again, oops, that is an unnecessary asterisk. Scent, smell, fragrance, olfactory. All right. We hit the magnifying glass and here you go. Looks like there are currently 17 of these, right? You can clearly see Play-Doh right here. I don't know what some of these other ones are, but oh, Power Plus lubricants, that was going to be the fruit scented automobile oils and fuels and whatnot. Okay, so there you go. That's a brief little run anyway through different ways to take a peek at these. And I will tell you this, by the way, for some of you who aren't as familiar with our search system, remember when you're using field tags, you don't have to change the drop down over here. You just type in field tags and it's going to know it. It's smart enough to know you're using field tags. There are different ways to sort. There is relevance, and we can talk about relevance a little later on if you want to. If for those of you who want a more test-like experience in terms of the results being returned to you, you can use serial, and this is going to be the most recent ones. So for the most part, which have a higher serial number, like these are 9 7s. But if you want to go oldest first, you can switch it and go 0 to 9. These are, for the most part, it's sometimes a little bit out of order, but for the most part, it's going to get you kind of oldest to newest. So there you go. That's different ways to sort. Okay, so there we go, and we can talk about search, especially since we have Corey here, and he can talk more about design codes and things like that. All right, so as we finish out and move into some questions before we have to leave in about 19 minutes, these are in the deck as well, just so you have quick and easy access to some of the Team EP sections that we have talked about today, whether it's trade dress, color marks, and the other sorts of more non-traditional marks. Here's some quick ways to dive into the Team EP, the Trademark Manual of Examining Procedure, to get those links. Okay, so we are going to go into questions now. So I'm going to stop sharing my screen. All right, so I know we had some that came in advance, so let's try to hit those real quick here. Jen, I had one for you here about genericness and color marks. Right, I know that recently popped with regard to the MediSafe case, but could you talk about any other examples that are out there for genericness in non-traditional trademarks?
Sure. The two that come to my mind are, based on case law. There's Henry Jasmine Larian that was recently cited a generic configuration of a handbag, and then the Stuart Spector designs the shape of the body of a guitar. So there have been instances where the design itself is so common, so ubiquitous in the industry that it's not something that could be perceived and be registered as a trademark. Essentially, it's generic. So anytime you think of something like that, or when you're counseling your client and they're oh, I have this great design, but you go look and everybody is using that same design, that might be something where you got to do a little bit more research, say like what happened here, or are you policing stuff of this if you actually think it's your design. But there are many different instances where the design is going to be common, not unique, and meet that standard that Carrie was talking to about, unfortunately being generic and not capable of being registered as a trademark.
Excellent. Cool. Great. Thank you, Jen. Corey, I have one for you, since you are in some ways one of our search experts here today, about whether we're using AI in our search system.
So currently, no. The agency would like to certainly explore ways that we might be able to use. We're always innovating. I mean, we are in the innovation agency, and we're trying to always work those sorts of things in to our own practices, our own systems. We've been going through a really big overhaul of our internal infrastructure these last few years, and so it's possible that we may find ways to use it both effectively internally as well as offer it for customers externally. So we'll see.
Yeah. Okay. Yeah. Sounds good. I mean, look, yeah, folks, as Corey said, we are exploring all sorts of ways. I mean, if there's a way that we can get sort of image searching that doesn't involve design codes, or an alternate way of searching that wouldn't involve the design search codes, sure, we're going to be looking at it, ways that we can make it better. Sometimes people ask about that relevance by sorting when they're using our public search system, and it sorts automatically by relevance. That isn't necessarily AI. It's not learning. But what it's doing is using a fairly basic algorithm that is looking about the number of times that a particular term appears in our database. It might appear in a record, and so forth. So it's doing a kind of really simple analysis to say, is this relevant? And it's kind of floating those up to the top. But it's not the same thing as you might find in terms of it being a relatedness result, where it says these are related to yours. So I know they both start with RE, but they're not the same thing. This is our attempt at maybe it's relevant to you. And so take it as you will. Use it, don't use it. You can sort a different way if you want to. And the other thing I would note, sometimes people do treat our search thing like it's a search engine and be like, I looked at the first 3 results. It's just like any other search engine, right? I don't need to look at anything else at the bottom of the page or subsequent pages. Please look at them all. So just be aware of that. And by the way, folks, I will say this before, Carrie, I'm going to turn to you in just a second. We are open to your thoughts about how we might use AI in the future. So folks, if you're attending today and you have thoughts on how we could integrate AI into our systems or into our workflow, we would love to hear those ideas. Or if you're a person who says, I don't want you to put AI into your workflows, I like humans, that's okay too. We want to hear those things. We are open to all of your opinions and your feedback. And so please let us know. And again, AI would be a tool here being used by humans, not replacing humans. That's one of our guiding principles. Okay, so Carrie, let's talk about drawings Okay. And this was one of the questions that we wanted to make sure we hit is what if the applicant knows that they are going to need to submit a drawing that has multiple renderings? You talked about this during the slide deck, but I think it's important, that we raise it again here because clearly it's something that people are interested in. So this could be a mark that it's going to be in 3 dimensions, right? Like that Dutch Brothers cold brew or the pair of jeans with the like bullet-shaped things on the side, or something on a wine bottle. So someone knows they're going to have to submit multiple drawings, which requires a petition. How soon should people submit that petition?
As soon as possible is the short answer. Yeah, the newest one we're seeing a lot of is for sneakers. You need to view the sneaker in multiple views to get, a sense of the entire mark. So like I mentioned, you can file your petition as soon as you receive a serial number. So as soon as you have a filing receipt for your application, put the drawing with multiple renditions in your application. You don't have to wait and amend it later. You can file with the multiple rendition drawing, submit your petition right away. We will expedite and get it decided. And there's no reason we wouldn't grant unless the mark is not actually in 3 dimensions. So sometimes we have had that happen where someone files a petition for a regular 2-dimensional mark and we would just dismiss it and say, oh, you don't need to do this. So the one thing I wanted to reiterate that Corey touched on, though, is for those motion marks, Rule 2.52 has a specific provision for motion mark drawings. So that 5 freeze frame, like we saw with Pixar and HBO, that is perfectly fine. No petition is required. So you don't need to petition for that kind of drawing. It's only the more complicated configuration marks and where you need to view the mark from different angles to get a full sense of it.
Excellent. Good. And the other thing too, folks, is you can use our first action pendency to your benefit in these cases.
Right.
Right. Now, obviously, we don't want to have a long first action pendency, and our commissioner has spoken already publicly about our goal to push pendency down closer to 4.5 months, which is closer to where it used to be in that three-ish month range. So we're working on getting there, but still, even if it's say 4 months of pendency, that is going to be plenty of time for you to submit that petition, hopefully get that granted, so you can be ready to rock by the time that this your application drops into the docket of the assigned examining attorney.
Can I pop in to address something that popped into the chat, which I think is a wonderful suggestion, that can we get a checkbox to include the petition with the application form? I love that idea.
Oh.
We are exploring our petition forms that have not yet been moved to Trademark Center. But we are starting to plan for how that's going to work. We also do petitions to, expedite examination. Could that be included in the original application form? So we're definitely looking at all of those things. And in the next round of Trademark Center, who knows? Something like that might be possible. So I'm very excited about the options for our future petition filings once we move out of T's.
Yes, that is great. Yes, absolutely. And it's certainly something we can look into, folks. Thank you for that suggestion. Again, see, this is why you guys are awesome. We love to hear these suggestions and your feedback about things that we can do to make things better for you. And just to further expand on Carrie's point with regard to Trademark Center, as you are probably already aware, we're moving slowly to make sure that we're not just dumping a bunch of old stuff in Trademark Center, and we're trying to be very intentional about the creation of forms inside Trademark Center to, again, make them more streamlined, more clear, more concise. Doesn't need to be a one-for-one, whatever. So currently what we have in there now are, that's the base application. You have the capability to file some voluntary amendment stuff, and slowly we're going to be building out response to office action and so forth. So eventually everything you'll need to do will be available inside Trademark Center. All right. Looking at the clock, we only have 9 minutes, but I think we're going to have time to get through these. So Jen, question for you. And this one, oh yes, I know this one was submitted several days ago. Someone very interested in this. So in protecting a color, does the acquired distinctiveness need to be amongst a wide swath of the general public, or is it sufficient if the color of an item is known to the provider's small specialized consumer base? So think about somebody who's just selling to a small group of people instead of like the general public. How would we approach that, and what sorts of things in the application might come into play in that scenario?
Yeah, so you're really asking is how do we define the consuming public? And that's a question actually that occurs in any application, not just in color marks. But the identification is going to indicate the goods or services that the mark is going to be used with. So it's someone that is going to reasonably encounter those goods or services. So, when evaluating the evidence, we're not going to expect the entire swath of the consuming public to know a really niche area, if it's a specific industrial machine or something like that. But for something that is more widespread, like maybe a cereal box, we would expect anyone that goes to a grocery store, a larger swath of the consuming public. So it is going to be dependent upon what the identification is. Think that you can just have that discussion with the examining attorney, but it also is going to depend upon what it is in what is in the identification, and if there's specific limitations in terms of who the consumers are.
Yep, I love that. It's a great answer there, Jen. So for the submitter who sent this in, I mean, it's really part of the conversation for you to have with your clients, and also for the good legal counsel that you would give about what exactly you'll be putting into the application in the identification of goods and services. And so one of the things, thinking about this, and guys, correct me if I'm wrong, I think the MediSafe case, the green medical glove case, touched on this. So that might be another place to look as well for some recent case law on how we're sort of treating that stuff. So great question and great answer there. Thank you very much, Jen. All right, Corey, I'm going to be throwing this one to you. So let's talk about distinctiveness. All right, so when we're talking about evidence, that people there are practitioners might want to include, what are we looking for as examining attorneys? Any advice or sort of guidance you can give?
Yeah, and I know that something came up in the chat of how to attach this. So first thing would be you can include distinctiveness evidence right away in an initial application, as well as in response as part of attachments and stuff like that. But getting to the specific question, when we are talking about distinctiveness evidence, it's another way of asking the question: how is it that consumers have come to encounter a mark and associate it with a particular source, even if the source is anonymous? But they associate, this one product with this one non-traditional mark with there's only one people that do the bowling balls that smell like strawberries or whatever. So evidence that we use, sometimes it's simply time and use, but that's not typically the strongest, especially for non-traditional marks, just because it's an unusual sort of thing. It would have to be really extensive time and use. More typically, we will see advertising expenditures and sales numbers, dollars and efforts like that. Media coverage by third parties is typically stronger if a news weekly or something like that. I mean, just anything, social media commentary on this brand's bowling ball that smells like strawberries, they're the best. And then, last another is the applicant themselves, their marketing materials that draw consumers' attention to this. Like, we're Dave's Bowling Balls, we're the ones with strawberries. Look for our strawberry scented bowling ball. I keep coming to the bowling balls. I just think it's so funny. But that would be so we call that look for advertising. That sort of thing that the applicant, the owner, is trying to do to draw consumers' attention to these in particular. So that's usually the best kind of stuff that we see.
And I also just add to that, I think the importance of look for it, and also the statement that Corey just made at the end. What efforts has the applicant made to associate this mark? Because it is not a traditional mark, not something that might be immediately perceived as a mark in many instances, as the source of the product or service. That's really the core. So anything that can be provided to support that is things that the examining attorney wants to see as evidence. I know that's not necessarily fun for outside counsel, but it is really important. I always tell people, give us everything that you have, because we can weigh that and say we think it's enough.
Yeah, so Jason said at the front, we can't give you legal advice, but maybe we can give you marketing advice. So, or you can give your clients marketing advice, like do this sorts of advertising.
Yeah, and I think that's all part of the great counsel that we know that you as practitioners give to your clients is like trying to set them up for success in their application. The one thing I come back to, I always think about, and I forget, Carrie or Jen, if it was you who raised it with UPS and the "What Can Brown Do for You" campaign. If I'm remembering correctly, UPS applied to register Brown, and we said no, and so they came out with a "What Can Brown Do for You" campaign, and it was so successful that I think they no longer have it registered. They don't need to anymore, right? Because we have learned as consumers, boom, when we see brown, we know we're looking for UPS, and I think that's really pretty cool as a way to train members of the public. Like this, when you see this, this means us. And I seem to also remember a case, I think, with Timberland boots not too long ago. I think perhaps, and hopefully there's no Timberland attorneys on today. Sorry, I don't mean to call you out, but I think there wasn't enough look for evidence with regard to the sort of very specific things on the boot that made, when you see it, you knew it was immediately a Timberland boot. And I think the problem was, if I'm remembering correctly, they didn't have enough of the look for advertising in the record. So just things to think about. Okay, so look at it, 3 minutes here. Okay, Carrie, let me hit you with this real quick. Any recommendations on timing? Okay, when does it make sense for applicants and their attorneys to provide the evidence? Front load the application or wait until after the examining attorney has issued that refusal?
So my advice will be the same as it was for petitioning. If it's a non-traditional mark, you're most likely going to have to provide evidence of acquired distinctiveness. So there's certainly no harm in providing it up front. If you were going to argue, if you were planning to assert that the mark is inherently distinctive, that might be different. You might make a different choice there. It just depends on how you want to counsel your client. But front loading the application in most cases allows things to proceed quickly. You avoid that first office action refusal. It shows the examining attorney that you understand the evidentiary requirements that are going to be set forth, and you filed with what you think is sufficient to establish acquired distinctiveness under Section 2F. And then it gives you that, if you skip the initial office action, you get another chance, another bite at the apple, so to speak, to supplement the original evidence going forward. So as a bonus tip, I would say this is true for all things, especially, if I may, for petitions and letters of protest as well as responses. But remember to organize your evidence. So if your evidence is many pages, please have an index, and please explain, what you're submitting, where it is, what it's intended to show us. Because sometimes we can get huge amounts of evidence, and it's a lot to wade through, and you don't want the examining attorney to, see all these pages and not know where to find what you're, really stressing to them to make your point. So that's my tip.
Excellent. All right. Thank you, Carrie. All right. I'm looking at the time. We have 1 minute left. So if you guys are cool with it, I know we got some really great questions in the Q&A. I want to do a real quick lightning round, and I'll try to see if we can keep our answers super tight. But Corey, what about sheet music for a sound mark? Is that a good substitute for a detailed description of the sound in a mark description?
I would say no. I think the mark description, the DE field, to use the field tag reference, does have to lay out, in a text description of what the mark contains. It can summarize sheet music, but the sheet music alone isn't an adequate substitute. For someone who could read music, it's probably even more detailed and better. I can't read a lick of music, but so that's why I would need the mark description rather than, the treble clef and bars and whatever those notes are.
That's right. And also remember, folks, that think about this in terms of folks with low to no vision. The mark description field is a great way for them to be able to see what the mark is, even if they can't visually see it itself. So it's a good description there. Okay, Jen, real quick. I know you could probably talk for hours on this one. What about the combination of a color and the absence of a color in a single mark? Are those multiple color marks if you've got color and then like no color, like maybe a transparent background or something like that?
Okay, so first off, the mark is what's claimed, right? So if you have the absence of color, you're not claiming that as a portion of the mark. And that could introduce something where you have, if you are trying to claim multiple different colors in that area that's not being claimed, multiple mark refusal, especially if the color combined creates different commercial impressions. However, if you are actually trying to claim transparent, or what we would refer to as clear, that can be claimed as a color plus the other color. That would be a multiple color mark. So it really is how you're describing exactly what the mark is claimed and presenting, and then also, of course, matching has to occur, and you have to have the evidence to support, in the case of color marks, the distinctiveness.
Yeah, it can get a little tricky.
Yes, you're like,
yeah, but that's why
rapid fire.
Rapid fire, Jen. Okay, you did a great job on rapid fire. All right, so we are a little bit over here, Carrie. But what I want, let me just hit you with this real quick here about what about. So we talked about how the color is used, like on a product or on the product packaging. Okay, what do we mean by that, and what are we looking for in the drawing and maybe in the specimens?
Right. So how the color is used is really meant to mean where on the product or on the packaging you're putting it. So for, the John Deere tractor marks, there's many of them, right? There's some that show a green body and a yellow spot on the tire. There's some that show a yellow this and a green that, so it's all about the arrangement and the placement. And in the description, that's where you're really going to help narrow down what you're claiming as your mark. So your mark is, the color green as applied to the body of the tractor with the color yellow in a circle pattern on the tire, something like, I'm sure that is not the actual description, so I apologize if any John Deere lawyers are on. But that's really going to be how you're communicating to us how color is used as a mark.
And just to piggyback on that, because I saw a question about the swatch drawing, especially for repeating patterns.
Mm.
We will have a swatch drawing when you have a consistent usage across the different goods, but it's the same commercial impression, and it's not adequate to just have one representative use. So if it's the pattern is used all across different goods in 3 different classes, perhaps that's when you are able to show the swatch when it's the same consistent pattern. You might have a repeating pattern where it's just on a portion, on the edging, or in a specific area handle or something like that with respect to all of the goods. That would be something where that would be indicated, like you're just saying, the manner of use in the mark description, and then the mark description, and then the specimen all have to be consistent in how the reflection of that pattern, or whatever the mark is being claimed.
Yes. And the last thing I'll say, because we are a few minutes over, we got to get out of here, but I didn't get a chance to put all of the representative sample specimens on the slides, but there's some really great ones, especially if apparently you like cute animal figurines. The Herendi registration, which was the rabbit for the fish scale or fishnet design, you can really see in their specimens a wide variety of the use of that pattern across a whole different variety of, whether it's plates and bowls and teacups and all sorts of different things. It can really kind of give you a good sense of the sorts of things we might be looking for.
But it was still the same consistent pattern that you could see. And that, I think that's just important to indicate as well, because that's what happens sometimes, is that the pattern starts to be used in different ways. So I know you got to wrap up, Jason. We could talk about this for a lot longer. There are some really great questions that we have.
Yes. All right. Well, thank you, Jen. Thank you, Carrie. Thank you, Corey, so much. And thank you very much, folks, for being with us today and asking so many great questions. I haven't had a chance to look at all of them, but I'm very much looking forward to do so. We hope you found today helpful. If you like this topic, and you have suggestions for other things that you want to learn more about, please let us know. You can email tmwebinar@uspto.gov. You can also include it right now in the chat if you want to, and say, hey, we want to hear about this. You could also put it in the survey that you're going to get in a couple of days. So a couple of reminders real quick. Let me hit you with 3 of them. Yes, today's session was being recorded. We are going to post it to the website and to YouTube. It'll probably be in about 3 weeks. If you're someone who can hardly wait for the rewatch and you want to know immediately when it is available, I would recommend you subscribe to our YouTube channel at USPTO Video. You will get a notification as soon as any USPTO video goes live. And so USPTO video on our YouTube, on YouTube. That's our channel. The slides, they are available. They've been available. Let me see. Let me grab the link real quick. Let me open up the chat. I'm going to throw it real quick here into the chat. Where's the chat? Here's the chat. Boom. There you go, folks. So there is the link to the slides. It will also be in the email that you get in a couple of days. And for those of you who are attorneys who are with us today who are interested in CLE credit, yes, we have been approved for 1.5 hours of CLE in Virginia. And so everybody who attended today is going to get a copy of, I think it's the Form 2A is what it's called. It's a self-certification of attendance. For you Virginia folks, you can use that to claim your credit. For those of you who are barred in different states, not Virginia, you can still use that and just ask your state bar. And we have heard from many folks that they've been able to get credit based upon their attendance here today. For those of you watching this later in time, not on December 16th, 2025. Sorry, unfortunately, we cannot provide CLE credit to you. It's got to just be for the people who are with us today. Okay, so thanks again, everybody. Again, big thanks to Corey, to Carrie, to Jen, to Linda, the captioner, and also to Armando and Darcy for working the back end here with WebEx. We really appreciate it. Take care, everybody. Thank you so much.